what if I told you that in 2024, a century-old Privy Council judgment from 1923 was openly ignored by a state government in India? What if I told you that to stop one traditional lamp, 200 police officers were deployed, a High Court order was blocked, and a sitting judge was threatened with impeachment? This is not about religion. This is not about communal tension. This is about whether court judgments still matter in India. This is the Madurai Deepam case, and it exposes how fragile the rule of law becomes when politics collides with judicial authority. Let's start with the place. Thiruparankundram Hill near Madurai, one of the 6 sacred adobes of Lord Murugan, referenced in Tamil literature over 2000 years. This isn't just a temple on a hill. The hill itself is the temple, with shrines carved directly into the rock. So during medieval Muslim rule, a dargah, the Sikandar Badshah Dargah, was constructed on the hill peak on the same hill. That created friction. But here's the critical part most of the people don't know. This conflict was legally settled over 100 years ago. In 1920, the dispute reached court, and by 1923, it went all the way to the Privy Council, which was India's highest court of appeal at that point of time. The ruling was crystal clear. It said the Muslim community's title was upheld, but this is the critical point, only for 3 specific demarcated areas. And what were they? The area which has stones, the flight of steps that are cut into the rock leading directly up to the mosque, and the actual site where the mosque stands on the highest peak. It was a very limited, very specific grant of title. And what about the rest of the hill? The vast remainder of it? Crucially, the Privy Council held that the temple management, the Devasthanam, they retained the title and possession over the remainder of the hill. They called it the unoccupied portion. And this finding was the core part of the court's reasoning. The Privy Council observed that the construction of the mosque was, and I am paraphrasing here, an infliction the Hindus might have been forced to put up with due to the political climate of the time. This wasn't vague. This wasn't ambiguous. This was the final settlement. The boundaries were settled nearly a century ago, which brings us directly to the flashpoint of this current crisis, the specific circular stone oil lamp pillar that the petitioners wanted to light. The Deepathoon is absolutely key because of its physical location, relative to that 1923 ruling. Now, the original trial judge recognized the hill has 2 summits. The mosque is on the highest peak. The Deepathoon is located at the lower of the 2 prominent peaks, significantly distinct from the highest peak. And critically, where does it sit according to that old ruling? It sits squarely on the unoccupied portion we just talked about, which means it belongs exclusively to the temple. The court confirmed it's situated at a safe distance, not less than 50 meters from the compounded dargah. So this geographical and legal clarity that the land belonged to the temple, this is the absolute foundation of the High Court's 2025 ruling. The entire case rests on the fact that the land in question was already legally settled. Now, on the lower peak of this hill, far away from the mosque, stands a stone structure called Deepathoon. Its sole purpose is to hold an oil lamp during Karthigai Deepam, a centuries-old Hindu tradition. So over the last few years, temple authorities stopped lighting the lamp at this spot. They claimed it could create law and order problems. Instead, they moved the ritual halfway down the hill. A devotee recently challenged this in court, saying something very simple. This is a temple land. This is a settled right. You cannot abandon it out of fear. Since the temple's own executive officers told that the ritual would only be done halfway up the hill. What was the opposition's claim, and how did the court define the petitioner's right to even bring this case? The state basically argued that the petitioners were just, concerned citizens, and that they did not have an enforceable right or locus standi, which is the legal term for having the standing to bring a case to the court. Now, Justice G.R. Swaminathan examined the case and systematically dismissed this. He ruled that since the petitioners were Hindus and worshippers of Lord Muruga, they fell under the definition of persons having interest according to the Tamil Nadu HRNC Act. Now, that's a crucial point. It's a huge point. Under the law governing temples, if you are a devotee, you have a legally recognized interest in temple's welfare and critically the protection of its property. Now, the government tried every defense. The devotees have no standing, rejected. Relitigate land ownership, rejected. A similar case was dismissed earlier, rejected, because it involved the mosque area and not the temple land. Then the judge made a crucial legal point. The temple management has an obligation to protect its property. If they don't periodically assert ownership, like by lighting this lamp, they risk losing their rights over time through the law of limitation. It's like how the Madras High Court closes its gates once a year to prevent the public from claiming easement rights. So lighting this lamp isn't just prayer, it's a legal act of boundary assertion. The judge even noticed that the temple had previously put up a covering around the Deepathoon to prevent unauthorized lighting, something you'd only do if it was your property. So the order was clear. Light the Deepam at the Deepathoon and the police commissioner must ensure it happens. A binding court order that was backed by law. The government didn't comply. Instead, police were deployed to block access, the ritual was stopped, and now the state had rushed to the Supreme Court. Surprisingly, they're just not appealing the decision. They're trying to reframe the entire issue. The state now claims this is a land dispute that requires proper adjudication. But notice the language shift. Suddenly, this is called a land dispute. After a century-old Privy Council judgment from 1923 had already settled boundaries. Now let me ask you something. Does this tactic sound familiar? Because it should. Think about Ayodhya. For decades, that case was tied up in court under the guise of being complex land dispute that needed endless litigation. The strategy was delay, and keep it in legal limbo forever so that the actual resolution never happened. And that's exactly what we're seeing here. Think about the precedent that said, anytime the government doesn't like a ruling protecting property rights, they can just say land dispute and force you to go back to square one. That's not how the rule of law works. And then comes the truly terrifying part. Right after this ruling, members of the parliament from India bloc announced that they were filing an impeachment notice against Justice Swaminathan. Let that sink in. A judge applies property law, he protects a legally settled right, and the political response is to try to remove him from office. This is brazen political retaliation designed to send a message to every judge. Rule against us and we'll destroy your career. India has seen this before. Judges superseded in 1973, Justice H.R. Khanna punished during the emergency, pressure tactic against judges who refuse to comply. This isn't about one lamb. It's about whether judges are free to uphold the law without the fear of political retaliation. The battle now moved to the division bench. On December 15, the appellants unleashed a barrage to undo Justice Swaminathan's order. Dargah counsel T. Mohan claimed procedural violations, late in pleading, no time for counter, exclusion from site visit. He said crowds would block the path, making it nearly impossible for the minority to enjoy their 1920 granted land. One lawyer warned, if sentimental interest is enough, every Hindu in Tamil Nadu would claim Ayodhya. So where does it stop? Now the state side went further. The pillar isn't a Hindu Deepam structure. It's a Jain stambha or pillar for Munis at night and not Karthigai lamp. They cited books, similar pillars, elsewhere. No inscriptions proving temple use. They demand full civil suit with demarcation and proof of uninterrupted custom. Petitioners are now accused of vested interest stirring the pot, causing commotion and nightmare for officials. The bench has heard the matter all day and has posted continuation to December 16 with no reported final orders yet. Now my question is, why suddenly reframe a simple ritual on admitted temple land as a fresh land grab threatening minority rights? The 1923 Privy Council map and boundaries were upheld by Justice Swaminathan, so why reopen them now? And here's what should terrify you. If this works, it becomes a blueprint for every Hindu property right cases in India. So here's where we are. And listen carefully, because this matters for everyone and not just Hindus. Is that the rule of law, or is that the rule of litigation warfare? When a state government can openly defy a high court order for 48 hours, mobilize 200 police officers to block a court-ordered ritual, and then run to the Supreme Court claiming it's all a complex land dispute that needs more examination, what does that say about the state of judicial authority? When members of parliament can threaten to impeach judge for doing his job, what message does that send to every other judge in India? The threat to impeach this judge is an attempt to extinguish not just a lamp in a temple, but the very light of constitutional morality, judicial freedom, and civilizational confidence. Because once you destroy judicial independence and make settled law meaningless, you lost everything. The rule of law becomes ruled by whoever has the most political power and the most willingness to defy constitutional authority. And that should terrify all of us, regardless of faith or politics, because the same tactic used to deny Hindu rights today will be used to deny everyone's rights tomorrow. This case exposes the fault lines in our constitutional democracy. When politics decides that the law is just an obstacle to be defied, delayed, and delegitimized, we are not in a republic of laws anymore. We're in a regime where might makes right, where settled matters can be endlessly relitigated, and where judges who uphold the constitution become targets for destruction. The lamp they're trying to extinguish isn't just a religious symbol. The real question is, who decides the law in India, the courts or political power?